the 4 speakers. Britt from KW. And then I'll let them actually give a more detailed introduction of themselves and all the companies. And the next person is Xiaolin from Sanyou, Beijing. All patent lawyers, except me. And the third person is Britt. So let's just give you the fourth person is David Xiaolin. So we work on the slide format is that we'll, each of the panelists will give a 5-10-minute introduction of the company and their views in terms of the IP market. And then we'll have time for Q&A. As the introduction part of the thing got me interested in the IP is, my background actually is not IP. I used to run product groups in big companies like Xiaolin and also Inventec, and our engineers actually found a lot of patents. But lately, it seems like, with the proliferation of standardized designs for smartphone tablets, IP becomes a differentiation of product for companies to defend. That's why I think Apple filed a lawsuit against Samsung is to slow them down, because fundamentally, if you look at tablets today, they are both very similar, especially if they're all Android. So how many people in the room actually are product background? Just to show of hands. And how many people are from the IP background? It's a few. And how many people are engineers? All right. All right. We're good? Okay, just share a couple of slides to bring everybody up to the same speed. This is a slide done in 2012 with 5 major countries in terms of number of patents being filed. As you can see, the chart, the curve for China, it's grown through an amazing rate in the last few years. And this is a slightly older chart, which includes projection going to 2015, where China, the patents of application in China will actually surpass the U.S. And the two area of focus. One is in general about the different patents. 5 patents, trademarks, and copyright are not the same around the world, so the panelists will give you an idea of what the trade-off and differences are. And the other one is even for startups. Because of the entrepreneur demand program, I get involved with a lot of startups. And startups typically don't have a lot of resources and time and money to file for patents. But even now, I think that needs to be a discussion early on, just to make sure, because if you're the next Nest, which is the founder came out of Apple, who was on the team that developed the first iPod. And this became a very popular hit product, and then they got the lawsuit on Honeywell, because that is a core part of Honeywell's business. Next. And as a matter of fact, Professor Colin Chen just got nominated to be the IP advisor to the CTO of Obama's office, Todd. She has done a lot of work in this part of her study in terms of who actually got impacted most when there's that lawsuit. It's not big companies, because if you're Samsung, if you're Apple or Intel, you got money to defend, but it's really the middle and smaller companies. So that's the purpose of this topic of discussion, is to help with the panelists to share some of the ideas with you. I think that's it, right? Okay, so maybe we'll start with Britt, and we can, here are the 4 panelists, so I already introduced. So maybe we'll go by the So we'll start with Britt. Okay. Yeah. So you want to come up, or you want to use the mic?
I can use the mic.
Okay. So Janine, can you bring up Britt's presentation? Okay, now, okay, now.
Well, thank you. Well, that's coming up. Let me just say a couple things. First of all, whenever I talk with people at SBC Wireless, either groups or individuals, some people are concerned about commercializing product in the United States, taking it to China. Some people are, have concerns about products that have already been developed in China that are being brought to the United States. So I'm a trademark attorney, and so my focus is branding either way. Most of what I'm going to be talking about in the next few slides is basically products that are commercialized in the United States and are being taken to China, and what the concerns are, whether it's a brand expansion or whether it's a startup that is launching on a worldwide basis. So, but at the end, I'll say a couple of comments about what the factors are for Chinese companies that are coming into the U.S. market, because both China and the United States are very different environments in terms of branding requirements, in terms of legal protection. So again, I'm a trademark attorney, but my firm is K&L Gates. And just to give you a quick overview, because my marketing department doesn't let me go out without taking a commercial with me, K&L Gates is a global firm, but we have a local office in Palo Alto. We also have an office in San Francisco. But we're located in a lot of different countries around the world. We have lots of people working on lots of different IP issues. I focus a lot on the United States and also China, just simply because those are the two priorities in the world in terms of branding. 10 years ago, I was focusing much more outside of the United States and Europe, but China has just completely and totally overcome that. The interesting thing is Joseph put up the slide that showed the trend in Chinese patent applications. Actually, the trend in Chinese trademark applications is even more severe in regard to the United States, and that's because of some specific mechanics of how the Chinese trademarks are protected in China. There are many, many more trademark applications made in China because of the branding requirements and the brand protection requirements in China. And we have attorneys in China, and we work with lots of Chinese law firms. This shows a map. Again, the blue dots where we have IP attorneys. So just a couple of ideas on sort of lessons learned in brand protection. First of all, the key difference between the United States and China is that in China it is a first to file system. That means basically it's a race to the trademark office. So in the United States, you can use a trademark and have priority of rights. In China, essentially, with some exceptions around the edges, you basically don't have the rights until you get a registration. And by rights, I mean right to enforce. You don't have any right to enforce until you get a registration. In the United States, you may have a very good right to enforce without a registration. And also, the other factor with China is that there's a strong culture. Historically, there's been a strong culture that has encouraged copying and duplication of IPs. And you can see that one concept I got there. You can go ahead and advance. There are lots of different types of infringement in China. This actually happens to come from a police raid in southern China. People will think of very unusual things to do with your trademark in China. So you have to think very expansively about how you're going to protect your brand. It's not just sort of like in the United States where you might go, oh, well, that's unfair. You can't take that point of view because it's a very mechanical system. So in order to maximize the protection of your trademarks, in fact, someone else can get your trademark and then sue you or sue your supplier. And we see that very frequently, especially in the garment industries, all kinds of consumer products and things like this. People move ahead, register your trademark, and then you're foreclosed unless you go through a lengthy and somewhat expensive, not as expensive as the United States, but litigation proceeding. This is an example of someone who won. A restaurant guy in Shanghai came up with something. You can see the sort of paraphernalia that came up copying the Michelin Man. This is a case of local interest here. And some of you may have heard of the iPad case in China. Essentially, what this was is this wasn't specifically a case of someone going out and saying, hey, we're going to register your trademark first. But what it was is an example of a party who had registered the same trademark many years before. So strictly speaking, there wasn't bad faith at the time of the original registration for this iPad trademark, but it quickly became, because the company was going out of business, an example of, essentially opportunism. The lessons to be derived from this case is making sure if you're doing a deal in a trademark in China, acquiring IP rights, is doing the due diligence on who you're acquiring the IP from. And I'm sure my colleagues will comment on that as well, but in this particular case, Apple acquired rights to this particular trademark through a Taiwanese company. Those wound up not, that acquisition wound up not being valid in China. So Apple is held up. By the way, this is an example of another dimension of the problem, and this may not occur to everyone as an immediate issue, but one of the important aspects of trademark protection in China is protection for the Chinese character formatives that might make up the mark, whether it's a transliteration or a translation or something like that. So here's an example of a company that was held up actually for many, many years, and ultimately was ultimately unsuccessful. Probably had to settle the case. So this is the flip side that I was talking about. I just wanted to kind of see your thoughts for questions that you might have later. But one of the things that is clear is that the Chinese trademark protection, sort of structure, as it was for brands, is different than the U.S. structure. By the same token, it's different in the United States than it is in China. So companies that are coming from China, and if they're bringing their brands with them, or they're thinking of launching a new product here, they have to think in U.S. terms and think of the protection strategies that U.S. companies use here. As an example, there are litigation here is more complex and it's much more expensive. So you have to prepare for it if you're going to expand your brand in the United States. You also have to, because trademarks do not have to be registered in order for a trademark owner to have protection of the trademark and prior use. Pre-clearance searches of trademarks are much more important in the United States, and you have to go into much deeper detail than you do in China, where you essentially just search the register. So those are some final thoughts. And one of the things I want to point out is that we recently put together a paper on Chinese R&D centers coming to the United States and actually a full gamut of IP concerns that they might have in terms of protecting IP that they're developing here. And I've left several copies of the paper out there if you want to pull a copy, you're certainly welcome to.
Next is Xiaolin from Sanyou.
Good afternoon. First, really, I can make a brief introduction of myself and also firm. Because on my slide, I show some Chinese patent dates, some numbers, just to have an overview. The firm, Beijing Sanyou Intellectual Property Agency Limited, was founded in 1986. Just the next year, the first patent law was effective in 1985. We are one of the top 10 firm now. We are the first private firm at that time. Currently, we have about 310 people. Among them, there are 107 patent attorneys, 10 trademark attorneys, and also 14 general lawyers. For me, I personally in mechanical engineering and also with a legal background, so I'm qualified as a patent training, trademark, and also I mainly the patent field, not like Britt is a trademark law. So I'm in the patent side. Anyway, I handle a little bit cases in other field, representation, copyright, trademark, or domain name. Here are some numbers in patent applications. First is I want to say that in China, prosecution and also the filing number has been the number has been increased rapidly, and also the examination period has been shortened gradually. On the top, you can find last year the examination period for invention patent was about 22 months. Compared to the past, it's gradually shorter and shorter. And you can see the number increased rapidly. Last year, the filing number, the new filings received by the Patent Office had exceeded 2 million. And I think this year, by the end of this year, there will be about at least 20 to 30% increase. Here is the examination period. Next. I put several years data to show the development of Chinese patent filing. In China, we have 3 types of patent. Invention patent equals to utility patent in the United States, and the design is quite similar to the design patent in the US. So we have a special one which is called the utility model, which is protect the product with a special or with an exact structure and shape, and without specific information. So if the formality of the application meet the requirement of the patent law, then you can have the application issue. So you can find the utility model, the number is very high, the design is very high. But for invention, there's a smaller number. That is in 2005. So we can pay more attention to the number in invention, the model, and design, and compare to the next filing and also the foreign filing. So if you check next year, you can find that the foreign filing in invention application still exceeded to the domestic filing, but gradually changed next year. And you find the utility model also increased rapidly, and the invention still not much, but gradually increased. There's a change in 2009, so maybe next year. And you can see in the 2008 that the invention application filed by domestic applicant and also the foreign applicant are quite similar to that. And then next year, the invention filed by Chinese people exceeded foreign filing. So that is the point. And we can find in 2001 and the recent years, the domestic filing in invention patent exceeded the foreign filing by times. You can see that next one, please. And here is the last year. You can see the patent, or the patent is invention patent filed by Chinese applicants has been about 4 times the foreign filing. That means in China, the invention application is purely considered as a strong patent. For the human model, there's no certain examination, purely considered as a small patent or weak patent, each one. So from that, you can see the innovation, purely we can consider the invention application to represent the ability of the innovation. So in China, the Chinese people have increased the filing number in invention application, and that also represents certain kind of level of innovation. I found that there are 2 driven sources. That one is the government, Chinese government give a lot of support or similar policy to the Chinese entities to increase them file more and more applications, especially invention applications. Recently, they also encourage Chinese people to file overseas, in the United States and also in the European. And here, the re-examination request, you can find also increase. I think the reason that due to the increasing filing number of the invention application, so more and more rejections we receive. And the next is administrative litigation from re-examination and invalidation. In China, validity and the infringement are considered by different authorities. Validity will be decided by the patent examining board, and the infringement will be considered by the court. So here, re-examination and invalidation decision are kind of administrative decision, so it can be appealed to court. So for that number is quite stable. That means usually the invalidation will be derived from the litigation. If there is no litigation, no one will invalidate other patents. Here is a number. But from the litigation cases, that China has been the largest litigating country in the patent infringement field. I understand that the patent infringement litigation cases in the United States last year is about 5,000, if I'm not wrong. Last year in China, the People's Court received all kinds of patent infringement litigation cases, over 8,000. So, and another data showed that about 95% of the patent infringement litigations are among Chinese people. So about only 5% are foreign related. So that means you can see the in China the patent right can be enforced. Otherwise, there will be no such large amount of patent infringement litigation among Chinese people. And also for the recent years development of the patent law, also the patent practice, more and more consideration are being found in how to protect the patent, how to make the patent enforceable. So I received some questions from foreigners that always asking that whether the patent is enforceable, whether my technology, my patent can be protected. So through the number, I think in China, the litigating environment is getting better and better. So that's important. Brief introduction. Thank you.
Thank you. Next. Hi, my name is Mike Barn. I work at Fenwick & West. Fenwick & West is one of the native Silicon Valley law firms. The way I introduce the firm is we did the original incorporation of Apple. Most recently, we took Facebook public, and we do everything we can. So just all technology. So, the title of my slide, we're not in Kansas anymore. And this is a very quick overview of China versus U.S. We're not in Kansas anymore. This could be a U.S. company talking about China. It could also be a Chinese company talking about the U.S. These days we have a lot of large Chinese companies that want to come to the U.S. market. And they ask us a lot of questions about what is patent infringement like, or what is the patent system like in the U.S. So I'll have 3 slides. Go back one slide. So the general state of the patent law, I think the important thing here is that the Chinese patent law has only been around for 30 years. It was first passed in 1982. Before that, there was no Chinese patent office, there were no Chinese patent lawyers, there was no Chinese patent lawsuit. So they've only had 30 years to develop the law. And if you look at the history of the U.S. patent law, it has developed at different stages over its 200-year history. The Chinese patent law is generally following the same stages, not exactly because they were smart enough to
adopt some changes to avoid some of the mistakes in the U.S. patent law, but they're not quite at the same point that the U.S. patent law is, which in some respects is good. And so I think that's the big difference is just, how short the lifespan of the Chinese patent law has been. And where it is today is not going to be where it is 5 years from now or 10 years from now. So, next slide. So, the next two slides, on this slide I'm going to talk about applying for patents. And I think the big takeaway on this slide is things in China generally are cheaper and sort of more procedural. So, it costs less to get patents in China. The native Chinese companies, Huawei, ZTE, Tencent, what they pay for their patents is a fraction of what the native U.S. companies pay for their patents in the U.S. But some of that is because labor is cheaper in China. Some of that is because the types of patents that they're getting, it's not an apples to oranges, apples to apples comparison. In China right now, a lot of it is driven by numbers. People want to increase the numbers, and if all you care about is numbers, then your next step is how can I get the most numbers of patents for the least amount of money. In the U.S., the emphasis I think is more on quality and value. And if I'm going to spend $10,000 on a patent, how can I increase my return on that investment? So in terms of enforcement, on the books, I think the patent laws are fairly similar, but there is a lot of difference not in the patent law, but in the litigation law. How are cases litigated in the U.S. versus China? And the way I think of it here is, in the United States, patents are sometimes analogized to nuclear weapons. Patents are the nuclear weapons of intellectual property. If I launch my nuclear weapon, it potentially is the devastating strike against the competition. And I have nuclear weapons, they have nuclear weapons, and I need to build on my own arsenal to have this mutual assured destruction so that we don't sue each other. Things like that. And if I launch my nuclear weapons, it's a big event, right? It's going to cost me millions of dollars. I'm going to have armies of lawyers. It's going to drag out over years. And if I win, I'm going to get millions and millions of dollars in damages and things like that. In China, I think the patents are not as potent. You can think of them. They're not really nuclear weapons. They're more like regular bombs or regular artillery. So it's the patent suits are they're much quicker. They cost less. They're harder to prove infringement because you don't have the discovery that you have in the U.S. But the damages generally are low also. So there's just oftentimes it's not at the company event like it is in the U.S. That's about all I have to say.
I'm David Chapopin. I'm a partner at Pillsbury. We're a law firm that's been around for a long time. We actually incorporated Intel way back then, but sort of unlike K&L, we do everything. Our largest client is Chevron, our oil company. We do lots of stuff. We've got lots of corporate lawyers, litigation folks, as well as IP folks. I bridge the gap actually between all three. These first 5 slides, we can go through them quickly. It's kind of like Britt. We've got all kinds of people. We do all kinds of big stuff, whether it's corporate litigation, IP, in Asia, in the U.S., around the world. And so that's what sort of these first 5 slides say. Getting to substance, some of the things I'm going to say are going to be a little bit redundant because the folks before me have already done a good job of talking about it. I will start because my practice is primarily patent litigation, and then I help the corporate folks out in the big M&A deals or IPOs dealing with that part of the documents that deal with IP issues. And then, of course, with that, I also sort of strategize with clients as it relates to portfolio development. Typically, don't write patent applications myself, though I can. That being said, I'm very familiar with all these aspects. So the first thing I wanted to talk about is a bit in terms of differences for patent procurement between the U.S. and China on a bit of a practical level. As Michael had mentioned, there's a huge difference in costs already. Applications in China get 1K and paid for the US, that's about right. But there's also some really significant differences in examination and procedures. So how this all reflects and pans out, it'll be sort of interesting to see. In China, their examiners are very strict in terms of what the claims are that you say your invention is. Once you file your application originally, at least for a U.S. applicant filing for, they will not let you then alter what that is unless there's some very significant teachings to say that, you know, this combination should be able to be put together. And they also won't let you introduce anything that is extraneous here in the U.S. and all new matter. It becomes very, very limited. And so from a U.S. lawyer perspective, someone who has been practicing in front of the U.S. Patent Office, Figure 1 shows 3 blocks and it says A, B, and C. Figure 2 talks about D, E, and F, but you can't put all of those together because it doesn't explicitly say, even though logically you can read and infer that that's the case. That's just the way the Chinese system is. In contrast, the U.S. is the Wild West, okay? It's very lenient. We can add claims forever. We can sort of put in new concepts. And we have what's called a continuation practice that basically you can get a patent granted that's going to only be viable for 6 months at the end of its 19-year term, 20 years. And so it's a very different system between the two. And so that has to go into your thinking whether you're a Chinese company, what are you going to then file in the U.S.? And if you're a U.S. company, what are you going to do to make sure that what you file in China is going to be able to stand up and actually have the invention of a scope that you want to do? U.S. attorneys are used to filing broad application claims and then narrowing them later. But if the Chinese examiner will let you narrow them, maybe you should put some narrow claims in up front for an example. Similarly, next slide, please. There's significant legal differences on the patent litigation front, which have been talked about as well. In terms of costs, that's part of it, and your analogy in terms of, you know, cases in the U.S. can be really big versus China. I agree with, relatively speaking, that's the case. Some of the reasons for that, China's kind of based on the German legal system. There's very little discovery, whereas in the U.S., I get to ask the other side for everything, and they get to ask me for everything, and if I don't give it, then I get to file a motion to compel the court telling them they have to give it to me. That makes lawyers make a lot of money because the system is just expensive. The trials in China are sort of in the different regional courts, and there you have to sort of pick and choose which one you're going to use based upon, well, where you are, what you want done, who you know, and all kinds of things. In the U.S., we have a very broad venue statute, so that's why you see so many cases in the Eastern District of Texas involving foreign companies, because if you're a foreign company selling into the U.S., you can be sued for just about anything. The cases are different too. As I said, there isn't discovery in China, there is in the U.S. You've got a trial by jury here in the U.S. What a foreign concept for the Chinese, okay? 6 people who are going to then decide, you know, the life of my company? Ridiculous. And then the biggest one is damage awards. They're huge in the U.S. as compared to China, just generally speaking, for those cases that go to trial. In the U.S., do most cases go to trial? No, they don't. But nonetheless, the costs are much more significant, and so as a result, even settlements tend to be much larger. So my last slide, I'm going to mention some good practices that I see in bridging both country systems. Because these are things that you can do, particularly if you're a startup, thinking about putting your company together and sort of getting some legs on it. I advocate filing significant patent applications early and correctly, using an established patent practitioner. If this is going to be something that you're really going to value within your company, spend a little bit of money on it up front to get it done right. Draft broad and narrow claims that we'll be able to support them in both the U.S. as well as in China. Given first to file considerations, you have to be able to file early these days because your competitors are doing the same. I would pay attention to quality rather than numbers. People who are playing the numbers games, the Koreans did this 15, 20 years ago, okay? Then it was the number of patents that Samsung filed versus the number of patents that LG filed versus the number of patents that Hyundai filed. Okay, the same thing is now going on in China, it's just 15 years later. But you'll find that over the years, those companies that I just mentioned have gone towards getting quality patents. And so, as entrepreneurs, you should too. And if you're going to have to pick a country to file them, pick the U.S. We're the most litigious country on earth. Okay? We've got the largest damage awards. And so as a result of that, if you're going to go for a bang for your buck, file it here. If you have aspirations of actually selling or for being able to sue a significant number of companies, because a patent does not give you the right to do anything. It only gives you the right to exclude others from what you have an invention on. So you could have a Chinese business, a U.S. patent, and sue U.S. companies in the U.S. for infringing your patent, even though you don't even have any products here, just as a for example. The last two things I'm going to say have to deal with just hygiene. Coming from the perspective that I do of a firm that does a lot of corporate stuff, set up your corporate structure early. Make sure that the technology that you produce is actually owned by the company. Don't just do handshake agreements with your best friends, because those are there will be a dispute. Okay? You want to get assignments from employees to assign the technology to the company, as well as consultants. And then in the same vein, when you're entering into agreements, whether it's an NDA or anything else, pay attention to some of the details. And one of the things, if you're going to then be looking for an exit, you're licensing technology in or whatever, is look at the assignment provisions. Because while you may have the right to do it, if you can't sell that license that you have when you're going to sell your company, that's going to be looked at very skeptically when you're trying to exit. And so make sure that what you're licensing in terms of technology is going to go with the company when you sell it. So, in any event, those are my sort of overview on good practices. Last slide, thanks for listening. This is my information. I don't know if these are going to be available or not, but if anyone wants a copy, talk to me and I can get them to you later. Thank you much.
Thank you very much. So let's open up for the audience if you have any questions.
My question is for the patent protection. That's very hard to enforce the patent protection. For example, Google started from ground zero. Apple and iPhone started from ground zero. Facebook started from ground zero. They get your so quickly booming the this booming. The last time, Nokia failed, Motorola failed. They had 10,000 patents who doesn't protect the what's the way
Well, patents are difficult. When your patent issues, I look at it like you're only on your own 20, 30-yard line. Okay? You've got a long way to go before generating money for it. At the same time, not everything is the Apple versus Samsung case that you see. They're spending all kinds of money on just a few patents, and so that's not the typical case. That being said, patent litigation in the U.S. is expensive. There are alternatives if you don't have any money. It's called a contingency fee lawyer. Okay, there's lots of them I'll take your case on and I'll sue them, but then sometimes you get what you pay for independent. There's a lot of good ones out there. Anyone else have any other perspectives?
Yeah, I would say your comment is a compliment that we get from several entrepreneurs, and you know, patents are not magic, right? And when you're building a business, there are lots of risks. There are lots of things that can go wrong, and just because you have a patent doesn't mean that everything else is going to go well, right? So being successful in the business, being successful in the product, you need to have good engineering team. You need to be able to execute on your supply chain. You need to be able to get customers, sales, and things like that. And those are all much more important usually than what your patent protection is. Your patents are, and your IP generally are one factor. It's not going to, it's probably not the most important factor.
typically, when you start up your IP, it's part of your value add to whatever product solutions. Because if you think day one you want to, develop the IP is to enforce it, you better have a lot of deep pocket, right? I do have a question actually in terms of, is there a grand plan in China to boost up all these filings?
Maybe it's hard to say whether there's a grand plan. I think the patent filing depends on the applicants, some entities or individuals. Anyway, in China, the government will have some policy to encourage more and more patent filing by Chinese people, including individual and companies. And they encourage not only the filing but also technology innovation. I think China is going. The purpose is to change from the largest productivity company to the largest innovative countries. And for some policies, different level of government, like the city level, provincial level, or even county level, they do have their own policy, like to encourage Chinese company file the innovation application, and the innovation has been granted. Then there may be some money back, kind of refund from the filing, including the official fee, maybe part of the attorney. And that's one aspect. Another aspect to encourage the patent filing that in China, if a company is recognized as a high-tech company, then the company can receive a tax deduction about 2% for the entire company tax, usually from 25% to 15%. So that is a great incentive for the Chinese company to file, even some Chinese subsidiaries of foreign company. Here I say the Chinese company doesn't mean the company owned by Chinese people. That means Chinese legal entity. So there are lots of Chinese entities established by the foreign company has received a lot of support from Chinese government. So that is, I think that is a part of it.
Any other questions from the audience?
Like you mentioned, our legal system here is 200 plus for IP protection in China, like electronic. Assuming number of years brings a sophistication in the legal system, that is the assumption. Is there any plan in China to accelerate the legal system for IP so we can manage it better in the next day?
Actually, this ties in very well to the last question. I think there is, because I think the Chinese, this is all my own speculation based on what I observed. But I think the Chinese are very deliberate in terms of, when they put together the patent law, right? They looked around and said, oh, the Germans are doing this, the Japanese have this system, the US have this system, I like this part, and I like this part, and I like this part, and let's put it together like this. And then if you look at how the patent law has developed historically in each of those countries, there are these different phases. And I think whether it's intentional or not, actions that the Chinese government are taking basically have the effect of accelerating through those phases. The amount of progress that the Chinese patent law has gone through in the past 30 years has taken much longer than 30 years for the U.S. history to go through that. And so, for example, if you look at the U.S. history, there was a period of time where no one was filing patents. And then there was a period of time where people started to file patents, but all they cared about was the numbers. And then it got to a period where they cared less about the numbers and it was more about the quality or the value, the business value of the patents. And that's sort of the progression of, I call it the progression of the patent system. And, I think the Chinese government, they were not, in the not too distant past, they were at a point where people were not filing very much. And I think they sort of recognized, well, the next phase is to get people to file even if they're not very good quality, but just to get them to file, change that mindset and the incentives that they have, I think that will accelerate.
Any other questions?
Maybe I'd like to add some more information about the differentiation system. I think for the patentee, the patent owner, maybe several factors are concerned for them to take action. First is the cost, and then the remedy. So cost, as Michael said, in China the cost is quite inexpensive because the procedure is shorter. Usually, for the first instance of litigation, you can expect it can be finished within 1 year, and the cost much less than the cost of the United States. And so that means if an individual, especially for some small company or startups, they have the capacity, or they will be very brave to sue a large company in China because there is no complicated discovery. You need not to pay a lot of money to the attorney to continue the case. And the next is the remedy. Usually comprise the injunction and the damage. So injunction in China, if the court finds infringement, usually the basic rule is to grant injunction. So there's no kind of debate rules in China. There's only one exceptional case in China that no injunction is granted. In that case, the accused product or some plants supplying local residency power. So if the injunction is granted, then the plant will be shut down. Will affect the local residents. Only in that case. So in a general case, you will expect injunction if you win the infringement issue. But then damage, I would say in China from those cases, damage received by the patent owner were quite low compared to the situation in the United States. Anyway, if we examine the law of patent law or some regulation for calculating damage, in China the rules are quite favorable to the patent owner. We have several rules. So the first consideration will be the loss of the patentee, and then the profit of the infringer. Next is the reasonable royalty, and then the last will be statutory damage that is not available, if the evidence is not available to calculate the first three methods. So I understand in the United States that sometimes it's difficult to have the loss profit. Lots of cases will be decided by the reasonable royalty. So in China it's different situation, but the reality is that there's no discovery. So it will be difficult to prove the exact number of the loss or single profit. But there's a new proposed amendment for Chinese patent law. The draft has been submitted to the Congress. I think it's hopefully it will pass. That's in the proposed amendment. There are lots of new mechanisms to give some power to courts or to the local intellectual property authority to handle the damage issue. For example, the court has the power to order the defendant to provide some evidence to show the exact number of their manufacturing and their sales and the profit, like the accounting book. If the defendant refuses to submit those evidence, then the court can decide to make a decision against them, maybe accept the number claimed by the plaintiff or the number he considers suitable. So there are lots of new development of the Chinese patent law. I think the reason that 95% of the litigation are among Chinese people. So the government, the Congress, and also the Supreme Court really consider how to protect the patent, how to make the patent enforceable. That's my opinion. Thank you.
Okay, I think our time is up. So, I'm sure the panelists can stick around, and then if you have any additional questions, feel free to come up to them. And I think the slides will be posted on the website. And tomorrow morning, I think, 9:30, Xiaolin will have a dedicated session upstairs to talk about how to obtain a high-quality Chinese patent. So if you want to understand more, that would be a session tomorrow morning. Thank you very much, and thanks to all.